Well, I'd like to welcome everyone today. Our topic is employee benefit plans. Are you meeting your fiduciary responsibilities? I'm one of the three presenters. The other two, Rick Wagner, will talk about plan compliance, and Anders Ericsson will talk about cybersecurity as it relates to employee benefit plans. My topic today is oversight of the retirement plan investments, and that's your role as the business owner, plan sponsor, fiduciary in making sure you're properly managing and monitoring your qualified plan investment lineup. I'm going to walk you through several items today, including how to comply with ERISA 404C. That's one of the safe harbors that's available to you as a plan sponsor and fiduciary. Talk about managing your qualified default investment alternative, understanding your plan's annual participant fee disclosure, something you really do want to become familiar with, understanding plan level fees, something you'll hear advisors like myself refer to as the 408B2 notice, but really it's a discussion about the plan level fees and notices to plan sponsors about the function of their plan. We'll talk about recognizing revenue sharing, the concept of revenue sharing. What is it and what does it mean? We'll talk about benchmarking of fees and expenses, how you can do some simple benchmarking of your plan and see how it stacks up against others. And then finally, understanding and using your plan's investment policy statement. So first, we're going to start with 404C. And I'm not going to read these obviously line by line. You wouldn't like it if I did that. It would get really boring. But if you focus on that first box, 404C relieves plan sponsors and fiduciaries from some of the liability for losses resulting from participants if the participants make their own investment selections. So it's all about having a method for your participants to choose from the investment lineup to make a prudent investment choice, and then for you to be absolved of some of the responsibility for that by virtue of the fact that they made their own investment selection. But there are several things you have to put in place in order for you to qualify for that safe harbor. For one thing, it applies only to participant-directed investments and not to any other investments that might be required by the plan sponsor, and we'll talk a little more about that in a moment. To take advantage of it, though, your plan has to satisfy these three requirements. These are the keys. Investment lineup. There are some specific requirements from ERISA for the number of investments and for kind of what the composition of those is. You've also got certain plan design and plan administration considerations, and then there are some information and disclosure considerations, and the information and disclosure considerations are really important. Let's start with the investment menu. So I kind of have this first slide in question form. Does the plan allow participants to make their own investment choices? Does it offer 3 or more investment options? The third one, does it offer at least 3 core investment options that are materially different? Now, number 2 and number 3 seem really similar. Some people combine those into one. I wanted to distinguish a little bit for you because the real objective here is sort of captured in bullet point number 4, which is really the Department of Labor wants your participants to be able to take whatever those choices are that are available and mix and match them in a way that would be appropriate and prudent for any participant with any risk level or any financial situation. So that's really what this is all about, is making sure that no matter how a participant is wired with regard to the management of their money and their risk, that they can mix and match from among the choices in your plan and come up with a prudent investment selection. And then is each core option in and of itself diversified? Diversified is a little bit subjective in nature, but to give you a big picture sort of overview of what diversified is and what it isn't, if you had 3 investment selections, 3 funds, let's say, and if each of those funds consisted of only 10 core underlying stocks or bonds, that wouldn't be very diversified. But if each of those options consisted of 1,000 underlying positions, that gets a lot closer to meeting the ERISA requirement for diversification. And while there's really no hard and fast requirement on what that magic number is, you should sort of think about this globally. A big number, highly diversified, means something closer to the thousands than it does to the dozens of different underlying investments. So then, in addition to the investment lineup, there are plan administration and plan design requirements. So, are the transfers between the core investment options allowed at least quarterly? So if I'm a participant, can I go in and at least quarterly change my investments? And in fact, if we go into a serious financial crisis of some sort, can they make those changes more frequently if it's warranted? Are there at least 3 core choices? So you see that notion came over from not only the investment side of the requirement into the plan side of the requirement. Are there at least 3 prudent choices? And then this one, are the transfers allowed into the core investment options as frequently as they're allowed out of the most volatile? So the bottom line on this is if you have, say, a range of investment selections from conservative to aggressive, and someone's in the most aggressive investment option, and something happens to the economy that's a hiccup and the markets start to drop, ERISA wants your participant to be able to get into one of those more conservative choices at least as frequently as the plan allows them to get out of the most aggressive choice. So again, it's all about giving your participants good, prudent choices for how they can manage their own money. Another thing, I'm not going to touch on all these bullet points in detail, but is there an identified plan fiduciary responsible for ensuring that if your participants change their investments, that it actually happens? And typically that's going to rest with the record keeper. If you've got an electronic system where participants can log in and see their accounts, they're typically going to do it online. And that is, again, going to mitigate some of your responsibility. So the ERISA 404C has some disclosure notice requirements. You have to provide notices annually. Most record keepers are going to give you the notice to distribute to your participants. It's important that that notice says that plan fiduciaries are not liable for losses resulting from a participant's own investment instructions. So you not only have to make it a part of the plan that you're not responsible if they make their own bad choice, you have to tell them that if they make their own bad choice, you're not responsible. And that comes in the form of that notice. Of course, there have to be descriptions of the investments. There has to be disclosure about where and how they can access things like operating expenses, prospectus for each investment choice, etc. And all of that's going to be contained in that 404C notice. Another item that figures into this is a qualified investment alternative. So we refer to it in short as QDIA. And this is simply a default investment choice such that if your plan makes contributions on behalf of a participant, that there is a prudent selection for that money to get invested into, even if they fail to check the box and pick their own investment. This might come up sometimes if you have a plan where it is primarily employer contributions going in, or where maybe the first round of contributions is employer only and maybe the participant simply hasn't signed up to do salary deferral. But in that case, there are some guidance, or there are some guidelines for how that has to function. So procedurally, you've got to give your participants the opportunity to direct their own investments. That's what we've already talked about. Make their own choices. Then you've got to provide that default fund or a default set of funds, and then you've got to notify them at least 30 days before the end of each plan year whenever the new plan year is going to start, and 30 days before they sign up initially. Most of the time, your financial advisor or your record keeper is going to provide you with those and help you do that in a timely fashion. So with regard to the qualified default investment, it's got to be a mix of funds, or it can be a mix of funds that takes into consideration age and retirement date. So that's what we call a target date fund. If someone is going to be retirement age in the year, roughly around the year 2040, they might pick a target date 2040 fund. Another method for meeting the default investment is if you use a manager, a money manager in your plan. Typically, this is going to be some contracted party that's providing what we call 338 fiduciary services to your plan. In other words, by contract, they are providing the fiduciary oversight of the investments, and at the same time, they're going to typically be the investment manager and providing the investment lineup. They will usually have tools so that for some nominal fee, your participants can check a box and say, yes, I want to use your services. And for that additional nominal fee, a participant can opt in and then have the money manager tell them which investment they should be in and manage it for them. Another way to do it is to have what we might call a balanced fund or a moderate fund that's something appropriate for pretty much anyone in the group, something that's very middle of the road, doesn't take a lot of risk either way. And then finally, some other requirements about how frequently you can transfer in and out of those funds.
All right, so I know this says polling question number 2, but we have not done polling question number 1. So we'll go ahead and do polling question number 2 right now and come back to number 1. All right, to take advantage of ERISA 404C, the plan must satisfy 3 categories of requirements. And that poll is now open.
All right, congratulations. 82% picked the correct answer, which is investment lineup, plan design administration, and information and disclosure. And those, of course, are the items that we just discussed. So good job, everyone. Okay, so when it gets to the annual participant fee disclosure, this is an important tool. Sections 401A, 1A, and B requires fiduciaries to act prudently and solely in the interest of the plan's participants and beneficiaries. So I'm going to let you read the details here, but I'm going to cut to the chase. What you want to do is ask yourself this question: am I, as a plan fiduciary, being reasonable, prudent, and transparent with the way I'm managing this plan? And I'll just tell you that because I help a lot of Eide Bailly business owner clients set up plans because it's good for the business. It's good for them for their own tax savings for the business and their own tax advantaged savings. Those don't have to be two mutually exclusive goals. You can achieve that goal as the business owner and still act entirely and solely in the interest of the participants and beneficiaries. It comes down to managing the plan well, having good plan design, and seeking good advice. And that disclosure is going to disclose all the parties involved. So at the plan level, we have the 408B2 notice. It's got to basically describe at a service provider level how the compensation works, who all you're paying fees to, and what the purpose of those fees is to each of those parties. Should address whether the allocations, in other words, how the fees are allocated to participants, which fees are allocated to participants, and how they're allocated to participants, and are those fees being provided as part of the record keeping for the plan, the platform fees. And then some of the service providers must disclose an investment's annual operating expenses. Frankly, I think all plans make the operating expenses available. And if you aren't seeing those, you should ask your advisor to go over your 408B2 notice, explain all this to you. So the disclosure must include total operating expenses. And if the service provider uses electronic means to disclose all this and make it readily available to the fiduciary and plan sponsor, and if you make all of the fee data at a participant level available to the participants, you are going to be going miles toward your own compliance with what the Department of Labor wants you to do as a plan sponsor and fiduciary. Revenue sharing is a little bit of an obscure topic because it refers to payments typically made by like a mutual fund, an investment manager, etc., for work in keeping track of the ownership of those shares. So if your plan has a slate of mutual funds, some of those funds may pay a fee back to the record keeper, you would see it in the retail investing environment as maybe a 12B1 fee, or a sub-transfer agency fee, like on a variable annuity perhaps. But those fees in a retirement plan, in the retirement plan world, are called revenue sharing. So as a part of that total annual fee that a fund charges at the fund level, that expense ratio, that fund company feeds part of that back to the plan. And there are a choice of ways for how to use that. You need to ask your advisor and plan provider to explain to you how the revenue sharing works in your plan. So if it includes revenue sharing, you need to include the allocation of the revenue as a part of your discussion for your committee each year. And Rick will talk more about the committee roles and responsibilities in a few minutes. Some participants, though, depending on how the revenue sharing works, may pay a bigger piece of the revenue sharing. So let's say you have 100 participants, 50 of them are invested in funds that pay revenue sharing and the other 50 are not. And let's say that all of the plan's record keeping and administration fees are coming from revenue sharing. Well, what the Department of Labor would say is that 50% of your employees is paying all the fees, and the other 50% of your employees are getting a fee ride on those costs. That's the kind of thing that you as a fiduciary need to become aware of, and ask your providers questions to make sure you understand it. Finally, we're going to talk about benchmarking. So benchmarking of fees and expenses really is a matter of periodically, probably at least every 3 years, comparing your plan to what's available in the marketplace to see if the fees that you're paying and the services that you're receiving in exchange are appropriate and are reasonable. And for you to benchmark your fees, you need to establish a process for doing it, follow your process, and then document your discussions that you have annually. And this is going to be kind of at an investment committee level. And so it should help you make the fees and expenses reasonable and consistent with industry standards. It's easier if you use a provider that charges only direct fees. In other words, if you can design your plan to where you don't have revenue sharing, all the fees are direct, and it's very clear who's paying fees and that everyone's sharing equally in the fees, then it's a lot easier for you to do a good job of comparing your plan to others and of making sure you're being reasonable and prudent with all your participants. So finally, your service provider may generate an annual benchmarking report for you. You should ask for it. Write down the name of that benchmark of the 408B2, which is going to sort of be the starting point for your benchmarking, and ask your advisor to your plan or your other service providers to generate a benchmarking report for you, and look at those fees and then study it, ask questions about it, make yourself very aware of how your plan stacks up against other options that are available, maybe even from other providers. And a simple benchmarking process is for you to determine the all-in cost of your plan. So if some of the fees you write a check for, you pay by invoice, maybe to your third-party administrator, for example. And if other fees are debited out of the plan assets, what you should do is, based on the total balance of your plan, divide the dollars spent and come up with a percentage that you're paying for each of those services. Add all of them up to determine what we call the all-in cost. And your financial advisor on your plan should be able to help you do this. Ask them. They should be able to do it, and you should ask them to help you do it. So compare that total to the all-in cost if you used other providers. And if you do that reasonably and do it at least every 3 years, you're going to have a good feel for whether your plan is prudently priced. Final topic, investment policy statement. Every plan needs one. It's a written document that provides direction and guidance for how you manage the investments inside the plan. It's to help you as the plan sponsor and the fiduciaries who work with you on the plan to make sure you select and monitor those funds in accordance with ERISA, that you're consistent with the exclusive purpose of providing benefits to participants and beneficiaries, that you satisfy ERISA's requirements. And so the following key items must be considered: the type of investments, what asset classes, selection and monitoring criteria, performance expectations, and then of course benchmarking of fees. So the thing that you can do to make sure you do this prudently is, as a fiduciary, understand that there are so many requirements, it may seem like this is a daunting task, but you can simplify this. You can wrap your arms around it. One thing to do is take your fiduciary role seriously. And that means on these topics that you may not understand, you're just being exposed to, ask for help. Ask your plan providers to help you and to provide information. Establish a process and follow it, and then maintain it and evaluate it and monitor your process and update your process if you need to. Be reasonable and prudent in your decision making. That's sort of the bottom line. Document your discussions and decisions, so if you're ever audited by ERISA, you can prove that you've actually been taking steps to be reasonable and prudent. And then the bottom line, this is what it's all about. Focus on what's in the best interest of plan participants and beneficiaries. And with that, I'll turn the presentation back over to Amy.
All right, sounds good. So Rick is still not with us, so we'll go ahead and move into Anders' presentation right after this polling question. So true or false, the Department of Labor suggests that you establish an objective process to aid in your decision making. Everyone submitted for true, so good job. All right, Anders, you now have control of the screen if you just click on it.
Good afternoon, everybody, or good morning, yes, for some of us. I'm going to begin our conversation about cybersecurity today, looking at two recent data breaches that happened the last couple of years, and talking about what those taught us about cybersecurity, how we should view it for our organizations, for our benefit plans, and how we run them. The first one we're going to look at is the EQUIFAX breach. I'm sure all of you are familiar with this breach, at least you knew it happened. It affected millions of people. But we learned some interesting things from the EQUIFAX breach. And so maybe just for by way of background, the breach actually occurred between May and July of 2017. It wasn't discovered until July, but it wasn't announced till September 7th, 2017. That gave the board of directors and the executives time to dump their portfolios before they announced it. But I want you to remember this date, September 7th, 2017. That's just a hint. You might want to remember that. But just to give you a little background on what happened with this breach, the hackers took advantage of a vulnerability in a web server. And now, you and I, when we go out and use the internet, we open up Chrome or we open up Internet Explorer, and we say, go to www.equifax.com. And our computer sends a request to Equifax's web server saying, send me the information for Equifax's homepage, and then that web server sends it back to us. So that web server plays an important part in the communication on the internet. And the software that runs that web server, one of them is called one of these products is called Apache, and a lot of companies use Apache as a web server. Again, it's just taking in requests for websites, and it's sending those requests, it's responding to those requests. Well, in early July or early January 2017, Apache knew they had a security risk. They had a flaw in their software, and they sent out an update and said, everybody who's using Apache, you need to get this new piece of software. You need to get this updated. And Equifax had been using Apache, and they had received the update, so it was sitting on their servers. They had just not deployed it, and it was that very vulnerability that they had not yet put out there that the hackers took advantage of. And because they didn't just take that simple steps in deploying the software patch they knew they needed to, they ended up with 140 million people had their personally identifiable information compromised. It might have been many of the people on this call here. It resulted in over 23 class action lawsuits against Equifax, and it's already cost Equifax billions of dollars. You know, I remember getting the email, or not the email, it was a mail a letter in the mail from Equifax saying, you may have been part of the breach. Go to this web address and we'll let you know. So I went to the web address, filled it out, and when I got done, it said, well, you might have been part of the breach. So I didn't really get any good information from Equifax. But what we learned from Equifax, and kind of what my own personal experience was, I thought, I don't ever remember giving my information to Equifax. And most of the people who most of the people's information Equifax had, they did not get it directly from those individuals. It was through a third party. Now, when I went to go sign on my house, I sat there with my realtor and had a big stack of papers, and the realtor just said, well, you can't read all that, so sign it all. And one of those was a disclosure saying, title company, you can share my information with Equifax. And so it brought to light this idea that we are sharing our information with people who are then sharing our information. And there's layers to this data sharing. And nowhere is this also manifested in the benefit plans. We are collecting information, and we rely upon others in many cases to help manage that data and process that data. And so Equifax taught us that we've got to be careful of the data we're collecting and who we're sharing that with, and who we're sharing our own information with as well. And so Equifax is the first breach I want to talk about. The second one was called WANNACRY, and it was a piece of ransomware called WANNACRY. Now, ransomware is software that gets, when it's malware, once it gets deployed on a system, it starts encrypting everything it can touch on that computer, on the network that you're on. It's going to encrypt everything it can, and it encrypts it so strongly that the only way to unencrypt it and actually use that data again is to have a key. Well, the hacker has the key, and the hacker says, I'm not going to give you this key to unencrypt your data unless you pay me money. That's why it's called ransomware. So WannaCry was one of these ransomwares that was first recorded in Europe in 2017. It was sent out, hit a lot of companies in Eastern Europe and in Asia. The healthcare system of Great Britain was affected by it. Lots of large companies, but also lots of small companies. It's interesting to just look about the origin of WannaCry. It was actually just, WannaCry takes advantage of a vulnerability in Windows that's called Eternal Blue. Eternal Blue is just a flaw in the Windows software. But Windows has lots of flaws, and those are constantly being identified. Well, this one flaw was identified by the National Security Agency, but they didn't tell anybody about it. They just called it Eternal Blue, and they put it in their back pocket because if you're ever going to go attack a nation state, wouldn't it be great to know a vulnerability in Windows? And so that nobody else knew. So they kind of put it in their back pocket thinking nobody's going to really know about this except us. Well, Eternal Blue was part of the WikiLeaks document released, and documents were released to WikiLeaks. Hackers saw that vulnerability on there, and from that created WannaCry. So this huge ransomware outbreak, we all have the National Security Agency to thank for. But the purpose of talking about this and why I want to bring this to light is because when WannaCry went out there, what we found was that the ransoms, again, the hacker has encrypted the data on this company, and they say, I'm only going to unencrypt this data or give you the keys to unencrypt it if you pay me a ransom. But the ransoms were between $500 and $700. It wasn't very much money. You'd have the whole health system for Great Britain in the palm of your hand. They can't do anything unless they give you give them the keys that you've got, and you tell them, well, I want a ransom of $500. And it didn't make a lot of sense until you realized that what they were doing is the hackers were going for quantity over quality. They were just hitting as many people as they can, and they ask them for $500. Well, they're less likely to go to the authorities. Those victims are less likely to go for insurance. There's less investigation, so you fly under the radar. And what we learned is that everybody's at risk. There's nobody who's not at risk when it comes to cybersecurity. All you need is an email address, and you could be a target of a hacking incident, specifically with ransomware. In fact, it's getting to the point now where you don't even have to be a very technical person. They actually have on the dark web out there, there's ransomware as a service, where if I'm a criminal, I can go out there, and this is a website called Carmen on the dark web. And if you go out on the dark web, you have to have a special type of browser. While you and I use Chrome and Internet Explorer, hackers will use what's called a Tor browser. And the Tor browser allows them to access some of these encrypted websites that are on the dark web. But one of these is Carmen. And if I go get an account on Carmen, I can upload my clients, and those are air quotes clients, because those are really the people you're going to go after. Those are your victims. So you upload all your client lists, it's just a bunch of email addresses, and Carmen takes care of everything. It sends out the phishing emails, it tracks who clicked on the links and where the ransomware has been deployed, it tracks your receipt of payments, and it shows you how much you've earned in Bitcoin and how much that Bitcoin's worth. So the whole point here is I don't even have to be a very technical person. I could just be a criminal who wants to go out and make some money, and it's all out there for them to do. So it doesn't take a lot of time. You don't have to be a large organization. Everybody's at risk when it comes to cybersecurity nowadays and being attacked. So what does this mean for benefit plans? What are the considerations you and your organization should be thinking about when it comes to cybersecurity? And luckily, there's been some guidance that's been put out there that's specifically for benefit plans. The ERISA Advisory Council in November 2016 released a report called Cybersecurity Consideration for Benefit Plans. And really the objective of this was just to raise awareness. We want people who are, or the individuals who are running these programs to understand that cyber risk management is important, and they need to begin to develop and think about cybersecurity as a program and not just as a one-time thing, and then, hey, I need to, this is something I should think about every once in a while. We need to have risk program management be an ongoing program that our organizations are trying to implement. This report was really good, and as we've read through this and looked at it, we realized that there's a lot of good principles here that relate to any industry, not just benefit plans. And so it's really worth working through and looking through this report and considering how it can impact your organization. And we're going to talk through the results of that report today. It's going to lead much of our cybersecurity discussion. There's two principles that the report focused on that are really at the heart of cybersecurity, and when we go out and help organizations implement cybersecurity, we focus on these same two principles. So I was really glad to see these in this report. The first principle here is highlighted in that cybersecurity risk management strategy cannot be a checklist. We can't think of cybersecurity as I've checked all the boxes and then I'm moving on. Again, it needs to be risk-based, and it needs to be a program that we're constantly thinking about. So what is important to one organization isn't necessarily going to be what's important to another organization. An investment, a good cybersecurity investment for one plan might not be the same good investment for another plan. So it has to be based on the risk to your organization. The second principle is that it needs to have the attention and commitment at the highest levels. And I Bailey, we say cybersecurity has to be top down. Because cybersecurity isn't about the tools you buy. It's not about the widget or the security software. It's about people, and people are reflective of a culture. When we talk about it as about a culture of security. And if you're going to affect culture and really make an organization secure and have that security culture, it has to be top down. It can't be IT trying to get security pushed up from the bottom. It has to be at the highest levels of organization. Cybersecurity is important, and we're pushing that down. So cybersecurity needs to be risk-based, and it needs to be top-down. The plan that the ERISA Advisory Council, or the paper that they put out there, really talked about establishing a strategy and focused on these 6 points. We're going to walk through these briefly today. The first idea here is, again, we got understanding the plan's data, making sure you've got a framework for cybersecurity process considerations, customizing a strategy, striking a balance, and state law considerations. So before we do that, we've got a polling question here. Amy, we're going to bring you back on here.
Okay, sounds good. Polling question number 4, so really it's number 3. When did EQUIFAX announce their data breach? September 1st, 2017, September 7th, 2017, October 1st, 2017, or July 29th, 2017?
Good job, everyone. That's correct. It was September 7th, 2017. So first thing we need to do is understand the plan's data. This is the first point that they made. And this is the principle of we're collecting a lot of data. We now need to understand what we're doing with that. So let's maintain an inventory of the data we collect, understand how it's being used and who has it, and make sure we're sharing it only the necessary information and assets. Sometimes we give individuals access to way more information than they should. Kroll Cybersecurity, that's a major player in the cybersecurity and in the e-discovery and forensics world, one of their executives had this to say, and I thought it was a great quote. It's time for companies to go on a data diet. Don't collect information unless there's either a documentable legal requirement for the data or a demonstrable business process in which it is actually used. Similarly, once information is no longer needed, it should be deleted. We've got to start only collecting the information we need to make sure we know who we're giving it to. The next principle they brought out was the idea of frameworks, and they pointed to one framework in particular by the National Institute of Standards and Technologies called the NIST Cybersecurity Framework. Frameworks are important in that they help us make sure that we've covered all our bases for cybersecurity. We want to make sure that we haven't forgotten something or left something out. This is an overview of what the NIST Cybersecurity Framework looks like, and it's helpful because you can see, you move from left to right, it kind of follows a process. Well, first you identify the assets that you want to protect, make sure we've got the right business environment set up and governance and risk management. Then we put in controls to protect that information, including like access to systems, training, data security, make sure our networks are set up secure. We've got the appropriate maintenance and updates to our systems. And now once we've got things set up, now we put in processes to detect. Well, let's monitor what's going on, make sure there's anomalies and events, we're highlighting those and someone's responding to them. We're continuously monitoring. It's an ongoing process. And then when we do detect something, we've got a process for responding to that. Now that leads us right into the next phase, which is response. And this is where a lot of organizations tend to fall apart, is we need to make sure we have a planning in place because we need to be able to have the right communication. Who do we call when we've had a breach? Is our lawyer? Is our insurance company? Is our cybersecurity help? Who do we contact? Who decides there's been an incident and can identify, okay, we need to kick off the incident response team. Analysis, mitigation, improvements, all these things need to be kind of planned ahead of time. And then how do we get our systems back online once we do have a breach we've responded? So you can see there's a process that takes place here. And this cybersecurity frameworks make sure that we've covered all our bases and we've thought of everything. What we find is a lot of organizations have about 40 to 50% of the controls in the front of this in place. But when you get back down to here to respond and recover, they've got more like 5 to 10%. We're really struggling in this respond and recover area. But unfortunately, the worst time to think about a breach and how you're going to respond is when you actually had a breach. You need to be planning ahead of time. Other process considerations they talk about are implementation and monitoring. So making sure that this is a program, this is an ongoing process that we're continuing that we're not just implementing one time, but we're constantly looking at how do we improve it, how do we monitor and make sure we know what we need to improve on. Testing and updating. This is the idea that it's not just a matter of trusting IT to make sure they got these things in place, but let's bring in and do some third parties, do some testing evaluation to make sure our security is in place. We're putting the appropriate reports to the right people, the governing bodies, the benefit committees, investment committees, make sure that they've got the right information so that they can give us feedback and guidance on what and they can give us the information to guide how we should be implementing these things to reflect the business priorities. Training, people are your biggest issue when it comes to cybersecurity. We need to make sure that our people are trained and up to speed on how they play important role in keeping our organization secure. And controlling data, we've talked a little bit about that. Controlling access specifically to data, making sure that people only have access to the things they need. And then data retention and destruction. All the experts are agreeing, and I read that quote earlier. But if you don't need it, make sure you're getting rid of it. And then lastly, third-party risk management. This is an area we see a lot of organizations struggle in. We've become an increasingly outsourced world where we look for centers of excellence. We try to bring in people to help manage our systems and our data. But what access are they being given to? What data are we sharing with them? Vendor risk management is an area that every one of us should be looking at, making sure that cybersecurity is considered as we begin contracting with third parties, and then we're laying out security requirements for those third parties. And then just begin customizing. Make sure you're customizing your strategy. Again, it's not a one-size-fits-all. That should be based on the risks to fit your plan's particular needs. It's constantly changing. The threats are changing, so make sure that you are constantly looking at it and evaluating whether something's changed. Some of the other things to consider, I'm not going to go through all these, but resource and cost are some of the biggest issues that organizations face nowadays. Do we have the right people to do this? We haven't invested in cybersecurity before, so where are those resources and where's that funding going to come from to begin investing in cybersecurity? What we help organizations do is bring to the table some practical solutions. Sometimes the stuff that organizations need to do, sometimes it does cost money. There's a lot of things you can do that don't, and beginning to identify those low-cost things to get the ball rolling, and then begin making a strategy to help investing in some of those areas that we need to improve on. And then the last area is just, go ahead.
Sorry. Not to interrupt, Rick just joined us, so leave him about 10 minutes or so if you can.
I'm actually just wrapping up. This is my last slide. So the last area they've got is just striking a balance with state law. This is a great quote. I won't read it all in the end down here, but what it really boils down to is that benefit plans often cover multiple states, or you've got participants or retirees that are crossing multiple states. So if there's a breach, if there's security requirements, it could impact or could have requirements coming in from multiple states. Understanding what those are ahead of time is going to be really important. So making sure you understand your particular ERISA requirements within the jurisdictions you do business, and making sure that you're considering those requirements, it will be important. And your insurance company will be a great resource for that. We've got an incident response team that also works across state lines, and they understand the different requirements of different states. And so making sure your FBI office is another good resource. So local FBI office. So looking and understanding what your requirements are, preferably before a breach, can help as you're beginning to make these plans, so you're not trying to pick it up at the last minute or when you've had a breach. So in summary, again, cybersecurity is top down. It needs to be risk-based. Begin looking at some of these resources that the ERISA Advisory Council has already put out there, some ideas. And if you've got questions about your particular organization and what some of these things mean, please don't hesitate to reach out, because we can help drive some of this stuff and help you align your cybersecurity to your business objectives. All right.
Awesome. Thank you so much, Anders. All right. Rick Wagner has now joined us. Rick, you should be able to unmute yourself. Oh, there we go. Rick, are you with us?
I'm with you.
Okay.
Can you hear me now?
I can hear you.
Great. Awesome. Well, thanks. And
You are good to go.
okay, great. Got it. Okay. Well, I apologize again for everybody for my travel challenges, but we made it. This is a little bit out of order, but hopefully this will give you a little context for the prior discussions. I'm going to talk about just kind of the ERISA and fiduciary responsibilities in general, to give you some context for how the other applications fit within that. Just real quick, you see that of a different brand here, different company. This is my consulting firm, and we have a strategic alliance with Eide Bailly. So we work closely, and I assist them in these ERISA qualified plan areas. So just to give you a little background, ERISA is the Employee Retirement Income Security Act of 1974. It came out of the untimely demise of Studebaker Automotive Company that went under in roughly 1964, I think. So and only 10 years later, the Congress was able to get this law passed. But it's important to not only understand the context, but what it does and what it doesn't do. ERISA doesn't require any employer to adopt or sponsor a retirement plan or a welfare plan. But if it does, then if the company does sponsor a plan, then ERISA imposes some obligations. Most of them are procedural. It doesn't really have a lot of substantive requirements. It kind of defers to the tax code for that, but creates procedures to help ensure that the obligations of the employer, the promises that they've made, are kept. So that's what most of the rules in the statute are for, and we're going to be focusing on the fiduciary section, which is Part 4 of Article 1 of the statute. So first of all, the ERISA fiduciary rules kind of evolved out of the common law trust law area and the fiduciary responsibilities of trustees for the beneficiaries. And the two key components of that were adopted effectively by ERISA are the exclusive purpose rule, or what's historically been known as the duty of loyalty, which means that the interests of the plan participants and the beneficiaries have to be put in line ahead of any other interest, whether it's the plan sponsor or the fiduciaries or third parties or what have you. So that is one critical component. Then the other side of that is the duty of care, which is really the more procedural one, and also known as the prudent person standard. It actually is a little higher than that, in that it is often referred to by both DOL and the courts as a prudent expert standard, because it's the prudent person in like capacity and familiar with such matters. And so the courts have interpreted that to mean that you have to be familiar with the requirements, and a lot of these rules can be very complex. So effectively what that means is if you don't have sufficient expertise, then you have a fiduciary obligation to supplement your expertise by hiring an expert, similar to the two previous presenters. So so it's not enough to just be a prudent normal person, you have to be a prudent expert. And then they codified a few incremental fiduciary responsibilities that they wanted to actually include in the statute. The first one is the duty to diversify the assets. This is really risk mitigation, and it basically incorporated some modern portfolio theory ideas to the risk mitigation process and the duty to protect the assets for the plan participants. Next, you have the duty to follow the terms of the plan, and because plans have to be drafted in a manner that is consistent with the statutes, that effectively includes the duty to follow the statute. And then lastly is the duty to pay only necessary and reasonable expenses. And again, that kind of goes to the issue of the duty to protect the assets for the participants, but is probably one of the most actively, or is the most actively litigated area, likely because it's so easy to quantify and point to. So that the fee, reasonable fee management is a key area of concern, and I know my colleagues spoke to that as well. So who is a fiduciary? Well, there are different kinds of fiduciaries. There are specifically named fiduciaries. That ERISA requires that you have at least one named fiduciary, and then you also have a plan administrator. Those are often consolidated in the same entity, and more often than not, that is designated as the plan sponsor. The overseeing the operation and administration of the plan is obviously a functional responsibility. The 316 plan administrator is the one that has the statutory obligation to comply with the reporting requirements of filing 5500 and the summary plan descriptions, et cetera. Again, they're often consolidated in the sponsor, but really, you know, these responsibilities are very personal. So often it flows through the entity to the individual that is actually carrying out the functions. So anybody who exercises discretionary authority and control over the plan administration or the assets of the plan can be considered to be a fiduciary. It's not always easy to tell. Sometimes you have job titles that you might think are fiduciaries but aren't, and other times you have folks that maybe aren't that far up the chain but act in the role of a fiduciary. Really, it's all about the discretion and control over the administration and or the assets. Sometimes it's hard to tell, especially on the clerical side, because if somebody is just doing kind of what they're told and really doesn't have any independent authority, then they're probably not a fiduciary, and it would go up the chain of command to the point where the person actually has the authority to make those kind of substantive decisions that impact the participants and their ability to realize the benefits under the plan. Investment advice and authority, you guys have already touched on. These are, again, specifically provided for in the statute. Anybody that provides advice to the plan for a fee is a 321 advisor, and kind of is a co-fiduciary, if you will, because they don't necessarily have authority, but they are providing advice for a fee. And then the 338 has discretionary investment authority, so that means they actually can decide the investments, and that makes them a fiduciary because they have control over the assets in the plan. The trustee is kind of a historical fiduciary because of the trustee has primary control or authority over the assets in the trust. The reality is that role has kind of diminished over time. Often the trust agreements delegate authority to other parties. Often the trustees don't even have physical control over the assets. they're usually housed at a custodian that may or may not be the trustee. So that is still has kind of the statutory authority, but practically is probably less important. And then it's important to know, and we'll touch on this a couple times, but the delegation of fiduciary responsibility is a fiduciary act. So anybody that has fiduciary authority, discretion and control, and then delegates some or all of that authority to another person, that's fine, and in fact often is recommended, because it may mean, you know, delegating to a more qualified person. But nevertheless, the delegation of that authority or fiduciary responsibility is a fiduciary act, and the individual that had it originally and delegated has a duty to not only prudently select that person, but continue to monitor it. And there has been case law where courts have, you know, kind of stressed that continuing obligation. It's not enough to just appoint a qualified person and then walk away. So how do we manage these fiduciary responsibilities? Well, as I said, these responsibilities are inherently personal. So even though you might have the plan sponsor that's the named fiduciary, the reality is that that the responsibilities of a fiduciary require an individual to act, and so even though the sponsor is the name, the individual is actually the person exercising that authority, and that makes them a fiduciary as well. When you're operating in a corporate structure or any company, generally speaking, the board is kind of where the buck stops, right? Because the board has pursuant to state law, has the statutory authority and fiduciary responsibility to oversee the operations of the company on behalf of the shareholders. So that means they have ultimate responsibility. And so with regard to ERISA, that fiduciary responsibility plan likely flows up to the board, and to the extent it's not delegated or assumed by others, it's going to live there. So you could have a situation where you have lots of different people that could be deemed to be fiduciaries, like the board, or maybe an internal person who's assumed some responsibility and those kinds of things. And fiduciaries have responsibility for their co-fiduciaries. So unless you can make an argument that you didn't have any authority or control or was properly delegated, you could get sucked into that role and potentially have personal liability as a fiduciary for breaches. The best way to manage that fiduciary responsibility is intentionally, and the way that's done is that you typically you would decide what the board wanted to delegate to another party, and then we'd write that down, and that's usually in the form of a charter. And generally speaking, it's the board will create a committee. The most common is an investment committee, but it doesn't have to be limited to investments. It could be administration, it could be just retirement plans in general, and you can define what roles you want that committee to assume in the charter, and then you also effectively at that point decide which fiduciary responsibilities are going to be retained at the board level. So you kind of pick and choose and you allocate them, and then everybody knows who's responsible for what. That isn't done as often as it should be, and what happens is then you find yourself in a position of trying to figure out where that responsibility really lives, who's kind of exercising control over those things, versus who may have delegated or has oversight responsibility, and it just can get really messy. So I highly recommend creating a committee and allocating the various responsibilities across parties to make sure everybody understands. And then also it makes sense to at that point to take advantage of the opportunity and define what the procedural roles are going to be, and that goes to the duty of care. So if you define what those responsibilities are and then how they're going to be satisfied, then it kind of creates a roadmap. The other side of that coin is once you've written it down, it's really important that you follow it, because it creates a really easy opportunity for somebody to come in and say, well, you defined what that duty of care was and you didn't do it. So that sounds like a per se fiduciary breach. So you got to be careful about about that, coming back to Hanya a little bit. On an ongoing basis, I strongly encourage the building of fiduciary files, and really the reason is that if you can't demonstrate that it's been satisfied, then the DOL and the courts have actually said that you didn't. So documentation is really, really important. I'm not going to go through all of these things that should be in the file, but just a couple of points. One is with regard to plan documents. Keep your plan documents. They're regularly amended and periodically restated, but it's really important to keep that historical record. I'm working on a correction now where we're going back 20 years to do retroactive amendments, and it's really hard to amend a document that you don't have. And then also with regard to those, make sure you get them executed. It's really common to see plans or amendments that aren't executed. The IRS generally will not accept that. So for determination letters or voluntary compliance, you can be out of luck if you don't have a properly executed document. So make sure that that those get executed. And then just a couple of points. One is with respect to the fees. We're going to talk about that some more, but that is an affirmative obligation to review the fees and evaluate the reasonableness and then conclude on it. And again, if you haven't documented it and it isn't in your file, then you're not going to be able to substantiate it. And the DOLs, that's the first thing they ask to see when they come in an audit. So make sure you do that as well. I know that we're right on the end of time. I'm gonna go ahead and wrap these up quickly and continue for a couple minutes, but I understand if folks gotta bail out. So who should serve on the committee? It really depends on what responsibilities have been delegated. So if you're delegating administrative oversight, then you probably want an HR person. If you're delegating investment oversight, then you probably want somebody that's familiar with capital markets. So it kind of depends, but they should match up. You want to meet, usually it's quarterly, but I've seen it as rare as a year. And you probably want to have an odd number to avoid ties. You don't want it too big because it just becomes very cumbersome to get anything done and even to make the meetings happen when you're trying to coordinate schedules and those kinds of things. One thing I would say is you ought to consider just outsourcing that. Remember the prudent expert standard. If you're not familiar with all the requirements, then you probably need to bring somebody in who is. And usually what happens is you hire somebody to come and educate the committee, but you could also just outsource it. Probably would make sense to retain like an HR person to serve as the internal liaison and communicate to the various departments. But outsourcing to a qualified professional that's familiar with the compliance issues, familiar with the fiduciary responsibilities, can actually reduce the fiduciary risk, because then all you have to do is establish that it was a prudent decision and then satisfy the monitoring requirement, rather than being responsible for the decisions themselves. So something to think about. And running, as I said, generally quarterly, but I've seen them as rare as annually. These are just kind of best practices for any committee or board for that purpose. I would say, it's good to have a chair that kind of runs it, set an agenda, keeps things focused, and then obviously retain the minutes to be able to justify that you satisfy your duty of care in evaluating the various issues and making decisions. Lastly, you ought to have liaisons on both sides, up and down. So if you've been delegated, this has been delegated from the board, sometimes you have one board member in, or you have the chair that communicates with the board. And then you might also consider having communication channels downstream so that folks that are participants understand how decisions are made and how that might impact them. So this is one that we touched on a couple times, and it's really important, again, because it's kind of on the top of the list of the DOL when they come in an audit, and that's the selecting and monitoring of the service providers, especially with regard to fees. So again, any delegation of fiduciary responsibility is a fiduciary decision, so it has to be done prudently, and you have to continue to monitor it. You ought to review all the agreements, and go through a thorough process in evaluating the alternatives. We talked a little bit about benchmarking, and there's even been some courts that have said that if you're not shopping this plan every 3 to 5 years, then you have no idea what the current market is or best practices, and you aren't satisfying your fiduciary responsibilities. So that's important. Again, probably the most important is with regard to the fees, not only making sure that they're reasonable up front when you retain the company, but ongoing monitoring. The DOL has the 408B2 requirements and the regulations around there, and they've specifically said that that the reasonableness includes a diligence element, and if you're not evaluating the fees and coming to an affirmative decision that they're reasonable, then you haven't satisfied your fiduciary responsibilities. And if you haven't done that, then that means paying those fees is a prohibited transaction. And a fiduciary that permits a prohibited transaction can be held liable for those. So it's possible that the fiduciary, if they didn't review them or the fees weren't reasonable, could be held liable for actually reimbursing the plan. So that's really, really important. And lastly, I think it's prudent to consider fiduciary training. It's for the people that are in that role acting as fiduciaries. It's really important that they understand it and how they satisfy those requirements. So having some form of training and periodic to make sure that new members are educated is an important part of the overall process. And that's it.
And it was a great webinar, and we thank you, and everyone have a great day.